Good morning, everyone. Welcome to our monthly webinar here. As always with these webinars, we do record them and they are made available on the CTR platform. And everybody who has signed up for this will get a copy of the slides. So for those of you who don't know me, I'm Ann Lavelle. I'm the compliance specialist here at CTR. And we do these monthly webinars, usually the second Thursday of every month. And they're different topics. Oftentimes they're suggested by clients and friends. So if you have a topic that you want or that you'd like, please feel free to send it in. And we try to cover what's of interest to the folks who are kind enough to listen. Next month in August, we're doing something a little different. We are actually doing cocktails and compliance, and the invitation has gone out on that. But if you want to join us, feel free to reach out to your CTR representative. And we're doing that at the Walnut Grill in Wexford. And hopefully that'll be a more informal, we can ask questions and talk and get some good food and drink too. And, talk about all these fun HR laws that everybody has to deal with. So again, recorded, the slides will be sent out. Give us a little bit of time on that. We usually have it out within 24 hours. I love to take questions. It's a better learning experience for everybody. So if you have a question, please put it in the chat and I will try to get to everybody's as we go forward here. So with all of that in mind, also I am speaking at the PHRA, the Pittsburgh Human Resources Association in September as well. So if you belong to that, I'll be there as well, droning on and on about in that case, FLSA classifications of employees, which is interesting because today we're going to start off as we usually do. And I did not undo my video. I wondered where my little face went to. Not that you need to see it, but there I am. Okay. We're going to start off today, as we always do with these seminars, talking about some important legislative and court things. So we have covered the new FLSA salary threshold and other webinars, as well as the duties test for that. But let's talk about that just briefly. This is the outline of where we will be today and what we will talk about in case you want to find something later. But just so that everybody's on the same page here, most people thought the FLSA rule would be delayed by the courts because the last time this whole issue came up, it was enjoined by the courts. They said, no, you can't do it. It's too much of a salary hike and that's not allowed by the law and whatever. And a specific court down in Texas had enjoined the enforcement of this a few years ago when this issue came up. That same Texas court said, this time we're going to do it a little differently. They did not stop this law from taking effect. And in fact, the only thing they did was they said, okay, if you're a Texas government employer, a public employer, as we call it, you don't have to follow this yet because it might be too much of an impact on you. So right now, as we sit here today, July 11th, for the last 11 days, you have been subject to the $844 a week if you want somebody to be exempt from the payment of overtime. Come January 1, assuming that no court steps into this muddle, it will go up to roughly 1,100. That number is not set in stone because it's tied to a metric that we won't actually know what it is until we get closer to that date. And then it will increase automatically every 3 years. Note that they still have to meet, these employees still have to meet the duties test. So just paying somebody a salary is insufficient to make them exempt. They have to be paid the salary, which is now $844, which is about $200 more a week than what it was. And they have to meet the duties test. So very, very important to have that going. There's a question as to whether any courts will block this. So far, nobody has bitten at that, but we did, for those of you who maybe are bored in life, I don't know, and follow Supreme Court decisions, we had something called the Chevron decision come out, which essentially said, hey, we're not going to give deference anymore to government agencies. And that's a really big issue that we'll talk about in August. But if this gets to the Supreme Court, maybe the Supreme Court will say, no, we don't buy into this, but right now we're stuck with it. So be aware of that. Know that we've been under this for the last 11 days. The expected injunction did not come out of Texas like it did the last time. And Texas has some of the most conservative federal courts out there. So if it's going to come from anywhere, it should have come from the Lone Star State, but it didn't. And we're subject to that until something else happens. And if another court does impose an injunction, it's a real muddle as to, well, if we paid for the last, let's say, month and the injunction comes in August, what do we do? But this is what we're stuck with right now. All right, moving on to the topic for today. We're going to talk about disparate treatment versus disparate impact. And again, this is a very casual webinar. Please feel free to put questions in the chat box or wherever, and I will try to get to all of them. So what's the difference? This sounds like all legalese, right? And who really cares? Because you guys are on the ground and you have to do the day-to-day HR stuff. And why do we care about this? So disparate treatment is very easy to identify. Disparate treatment is when I treat anybody who's in a protected class in a not so good way. So protected classes include gender, race, ethnicity, sexual orientation, anything pregnancy, anything along those lines. So if I come and I say, hey, oh gosh, that Ann Lavelle, first of all, she's female. You know, women, we just can't have them doing compliance specialist jobs. That's disparate treatment. Somebody has said something very negative that is based on my protected class, and that would give me, theoretically, a lawsuit to go after the employer to say, hey, you know, Joe came up to me and said, he just doesn't think we can trust women to be compliance specialists because women are too flighty and too concerned about their makeup. Whatever. Obviously, I'm making this up, and I always pick on myself so that I don't try to offend anybody else or any other protected class. We could do lots of things along those lines, right? There's lots of racial slurs we could use, ethnic slurs. You know, we've had problems historically. Every time there's world trauma or world events, certain ethnicities seem to get picked on. We've had that with Asians. We've had that with Muslims. We've had that with Jewish folks. All of that can come into the workplace, unfortunately. And when somebody says something or does something or says, hey, Ann, you know, you can't be a compliance specialist because you got too many kids and you're female and you're white. And I think compliance specialists should only be of XYZ race. We have disparate treatment, right? We're going to say or do something or treat me in a way based on my protected categories. And keep in mind, I pointed out that I was white. We can have reverse discrimination, right? Reverse disparate treatment cases. Well, what is disparate impact then? Disparate impact is kind of insidious. It's a facially neutral rule. So it's a rule that's applied to everybody. And if you read the rule, whatever it may be, or the policy, or the practice, or the plan, whatever we want to call it in our workplace, if you read it, you'd say, hey, there's nothing wrong with that rule, right? So every carpenter in our workplace has to pass a test showing that they know how to measure and use a tape measure. That's a facially neutral rule. Is that acceptable? You're free to weigh in and say whether or not you think that's acceptable or not. We want every single employee to have a certain level of education because we're a good payroll company. And here I am picking on my employer, CTR. And so we want everybody to have at least a high school education. So in order to work here, you got to have a high school diploma or a GED, the equivalent of it, to show that you have some basic knowledge. So we hope that all of our employees can provide good service and have some basic level of education for interacting with the public. Those are all facially neutral rules, right? Are they okay? Are they not okay? Nobody wants to talk to me today. Please feel free to put something in the chat and let me know whether you think that's okay. If we say, hey, all our employees need a high school diploma or a GED, or all our carpenters need to know how to use a ruler. I can tell you I could not be a carpenter because even though I measured twice and like cut once is the rule, somehow I still don't get it right. So in any event, there's no intent with the rule, right? It's facially neutral. It looks good. If you read it in a classroom or a business meeting, you'd say, well, that sounds like a good idea. But what happens with these rules is even though they're facially neutral and they look good on paper, the result of the rule is that you see a substantially different rate of selection among employees in hiring, promotion, or other employment decisions that works to the disadvantage of a protected class. So I have the rule that all my employees need a high school diploma or GED. But when I look at this statistically and I look at all my candidates and I look at who I hired, I say, gosh, all the men got hired. They all have high school diplomas. But you know what? Only half of the women made it through that requirement. And so I only hired 50% of those women. That's a disparate impact. And what the courts normally look at is what we call an 80% test. Okay, somebody has been kind enough to put a Q&A in here. And naturally, my little mouse does not want to work to get over to the Q&A, but I'm trying to get to your question here. Okay, so great. Somebody here said, hey, I would ask if it's an essential duty of the job. So is having a high school diploma, and this person, you're anonymous, and that's fine. You can always be anonymous. But I'd like to say, hey, kudos, you're on the right track of, is it an essential duty? We might use other legal terminology for that, but we're on the right track. We're saying, hey, is it necessary for my job? Can I justify it? Is there a legal justification to say the carpenters need to know how to use a ruler and all of my employees need to have a high school diploma or a GED because we want a certain level of competence within our workplace. We want people to be able to read at a high school level. We want people to be able to do math at a high school level, recognizing that not everybody in high school has even taken algebra, but we want some basic skills there. Is that acceptable or not? And even just with my very simple examples there, everybody who's on here could probably say, hey, I can make out an argument that carpenters need to use a ruler correctly to be able to do their job. But let me add one other twist to that. It's a written test. What if the person doesn't know how to read English, but can use a ruler correctly? Do we have an issue? So, we'll talk about some of these issues here coming up, but that the person who responded, and thank you for your response, is on the right track about looking for job relatedness here. So the test that courts often apply, although it's not the only test out there for this, is what we call the 80% rule. And those of you who ever took statistics, like myself, and hope that I'd never use it again after college, they actually start talking about standard deviations and the bell curve and all that good stuff when they look at numbers here in court cases. And so what we're saying is, if we have this facially neutral rule with no intent to discriminate, the impact of it should not affect minorities much more than the majority. So it should be a positive outcome for at least 80% of the minorities compared to the number of the majority that we took. And so in a very simple example, because we need to keep the math simple for me, if we had 100 white folks who applied and they all got the job, and we had 100 Black folks who applied, we would expect at least 80 of them to get the job in order to say, hey, we don't have an issue here. The disparate impact analysis is an issue that is very common with tests. Physical, skills-based, educational-based, and that's really been making the news lately because of the concerns about the cost of college and whether that's prohibitive and whether that keeps minorities out of certain jobs whenever a college education might actually not be as useful as some experience that people have in life or intellectual tests, right? Do I actually need to be able to read to be a carpenter? Is it sufficient that I can use a square and see the numbers and a level and a tape measure? You can tell I'm never going to be a carpenter because I barely know what the tools are called. It also comes up disparate impact in layoffs all of the time, and that's usually age related, but it doesn't have to be. And we're going to go through this in more depth here, but that's what we're looking at. Okay. Once again, my little computer doesn't want to go ahead here, but that's okay. Give me 1 second to get my little cursor over here and hopefully it'll show up. And technology does not like me. For those of you who have seen me on this before, here we go. It really doesn't like me today. I think my screen might be frozen. Give me 1 second here. Well, geez, anybody know a good joke why deal with this a second? Feel free to put it in the chat. I apologize for the delay here. And I'm not going to be happy if my screen's frozen. Completely have, oh, there we go. I think I saw it a second ago. Okay. Finally got it to move. Technology is wonderful when it works. We seem to have a little bit of a lag here on our internet for some reason. And I'm not even at my house, but that's okay. So hot button issues, in addition to the ones that I already mentioned about layoffs and testing, the EEOC every year comes out with what they call their enforcement priorities, and it's a list that they publish of what they really want to go after. You don't want a case with the EEOC on an issue that is one of their hot button issues that they've listed as an enforcement priority. Right now, the EEOC says AI is on their enforcement priority list because they think it's going to lead to disparate impact discrimination. Why do they believe that? Well, in their view, AI learns from historical information and has the inherent biases of people who program it and put information into it. And because in the EEOC's worldview, there is historical bias and historical prejudice, and they're right, there's been that. This is undoubtedly going to make its way into AI. And so if people are using, if HR folks are using AI or using third-party services that use AI, we're going to lead to situations where the AI screens out minority candidates for jobs or whatever it may be for promotions, transfers, etc. So be very cautious of that because that is their position right at the moment. The DOL, the Department of Labor, so the EEOC is the Equal Employment Opportunity Commission, and the DOL is the U.S. Department of Labor. And the DOL is, by the way, the one that enforces the FLSA and the new salary threshold, is concerned about AI making erroneous assumptions about who is or is not entitled to overtime. So their concern is that there will be programs out there where you input job duties and you say, okay, Ann's job duties are she cleans the floors, she fills the refrigerator with pop, and she does the compliance specialist thing on the side. Is she exempt or not? And if you put it into the program, it'll spit out an answer as to whether or not I'm exempt based both on my salary and the duties, and tell us whether or not I'm exempt. Whether that's right or wrong, it may not have the individualized analysis that that we hope, each employer is making with a job description. Okay, so somebody provided a comment here that I want to address, and I appreciate the sensitivity of this whole topic. So someone said that we should be using the term ethnicities as there is only one race, the human race, ethnocentrism as opposed to racism. So I do appreciate that comment, but let me counter that a little bit. And I'm also going to just say, so that people don't think I'm a total jerk, I have adopted children who are not the same race or ethnicity as I am. And when we use race here, we're using it as the EEOC uses it. The EEOC specifically lists race, not the human race, but race in terms of African American versus white as two separate protected classes. They don't look at it in what I view as a wonderful human view here of we're all part of the human race. I agree with that sentiment wholeheartedly. But as we talk about it in terms of what the EEOC will talk about, the EEOC identifies, and if you're ever a federal contractor or have to fill out forms like that, they will say, hey, who's this race? Who's that race? They don't lump them all together. And they'll also say there's different ethnicities, right? There's Hispanic, there's Asian, Hawaiian, Pacific Islanders. Did not say that right, but those sort of things. So I totally, believe me, with my kid, I talk about my kiddos, and you guys are probably like, oh, time to tune Ann out because she's about to tell a kid story. But my husband and I, based on our own sort of moral beliefs, have adopted several special needs kids. They don't look like me for sure. And that's because they are their own creation and they look beautiful to me. But I'm in no way trying to disparage any race or the human race as a whole. But that is how the EEOC reflects things in its documents. So just to be clear there, and I hope I have not offended anyone. Okay, moving on beyond the two hot buttons here for our wonderful government agencies that we need to be aware of because they're out there. Let's talk about how this all started with disparate impact. So unfortunately, people do dumb things. I know that comes as a shock to everyone, and that includes employers who do dumb things. And this started with an employer doing a really dumb thing. So it was Duke Power Company down in the South. And I want to give some context to this. So this case was decided by the Supreme Court in 1971. My kiddos would tell you that's the dark ages, even though I was alive during that. But anyway, Title VII had been passed in 1964. This was one of the first cases to make its way to the Supreme Court. Title VII, just so that we're all on the same page, prohibited discrimination based on certain protected classes: race, ethnicity, religion, pregnancy, gender. At that time, sexual orientation was not protected. It is now. But at the time, that's what we were working with. And so we have a company in the Deep South, and there was, at least historically, a culture there that was difficult. And Duke Power had maintained segregated workspaces. And I have a quote here that's directly out of the Supreme Court decision. So it's their words, not my words. And it shows you the time period, I said. So what Duke had going on was essentially 5 different workspaces. And Negroes, as the court called it, were employed only in the labor department. That was the heaviest duty department, requiring the most physically intense and dirtiest, literally dirtiest labor. The highest paying jobs in that position were lower than the lowest paying jobs in the other 4 work departments, workstations, which employed whites only. So that's what they had going into Title VII, right? So in the early 1960s, Duke Power had this set up. Title VII gets passed, and Duke Power knows they have to comply. So what did they do? Were they above board, upstanding citizens? Probably not, because we're at the Supreme Court. And they decide to implement certain tests on the same date that Title VII took effect. What a coinkydink, right? They imposed a preliminary requirement for employment, in other words, a hiring requirement in the four quote unquote good paying operating departments, or a transfer there too, of having a high school diploma or passing certain intelligence or aptitude tests. These tests were kind of general in nature and not necessarily related for the particular job. And somebody has already spotted this issue, right? The lower courts all said, hey, these are facially neutral tests that don't necessarily show an intent to discriminate, although they were implemented on the same day Title VII was passed. But of course, Duke Power argued, well, hey, we're looking for a facially neutral way to break up the segregation and put people in these departments. What did the Supreme Court say? How many people think the Supreme Court loved this idea? I guess nobody. And that would be the right answer. And this is where disparate impact came from. The Supreme Court said, hey, I don't care whether it's facially neutral. You haven't tied this necessarily to business aptitude or a business requirement. And you're not showing us why this is necessary, because for the past 50 years, you never had these requirements. And if we're talking about the Deep South in the late 1960s, the reality was more whites had their high school diplomas than did any other minority class. So right there, we had an issue. One of the things that has remained an issue coming out of this decision from 50-some years ago is whether or not it's okay to require a high school diploma or a GED as part of your hiring practice. I think it is if you can say, hey, our office, our plant, our factory, whatever it is, requires a certain level of knowledge. It requires that you be able to read at this level. It requires that you be able to do this, that, or the next thing. That may be okay. You may be better off with a specific aptitude test that tests that if you really feel strongly about it. And certainly certain professions like CPAs, attorneys, I was an attorney in my prior life for about 25 years. You have to have that education. You have to pass a licensing test. Those types of requirements that are actually government imposed, that, somebody have a license to practice law or a license to be a physical therapist or whatever it might be, or license to be a nurse, are very easy to defend, because it doesn't matter if it sort of weeds out minorities, because it's a facially neutral rule from the government and we have to follow that law. But when we're making up our own requirements and saying, hey, we want all carpenters to be able to read Shakespeare, we've got an issue. All right, moving along. So this was a very recent case. And we can see disparate impact in a test here. So we had for promotion, and remember we had the 80% rule. So we're going to look at that quickly here and talk about why it's not the only rule all the time. So these were police officers, Port Authority police officers in New York and New Jersey, who had to pass a 3-pronged test in order to get promotions. And so, pardon me, they had 617 candidates. And here's where the math gets more complex than I want to deal with. You can see on the screen what the breakdown was. For our purposes, they weren't interested in the 45 folks in other categories. We were mainly looking at the white versus black percentages here. They had a written test. And if we look at the written test, excuse me while I take a quick drink here, we can see that the black candidates did about 10% more poorly. If you actually work on the statistical numbers there, we should be more or less okay under the 80% test. Then we had the oral exam, where the blacks actually did about 10% point higher than the whites. And then we had the problem-solving test, where there's no statistical difference at all. They were both about 94%. Does this look good? The ultimate promotion rates, the actual test might have been okay, but here's what happened. The ultimate promotion rates, based off the testing, from an eligible list, took it as a top-down metric. So those with the highest scores got the jobs first, even though we had passing rates that probably were okay. It ended up being 78 white promotions, 5 black, and then there was like a little handful of the other folks over a 3-year span. So here we have a situation where the actual testing doesn't look that bad, pardon me, but the top-down scores that they used after the testing were a problem. And the court said, hey, that is disparate impact. Your testing system, as well as the concept of a top-down promotion, so we go from the highest to the lowest score, shows some type of disparate impact, and it's impermissible. I will tell you, when you get one of these cases, it's very difficult to unring a bell. How do you tell the people who have already been promoted, guess what? We made a mistake, and now you don't have the promotion. Really, really difficult. When you're faced with something like this, your best bet is legal counsel, because you want to be compliant before you have a problem and have to start undoing this, unringing the bell. Let's move to this. Knowing what that decision was about in New York and New Jersey, we get Connecticut into the mix here in a different case that went to the Supreme Court in 2009. And that one, the city of Connecticut, because they had some disparate impact issues in the past, paid an outside research and testing firm about $100,000 to develop and implement tests. So the test was based off job descriptions of the firefighter, lieutenant, and captain position for which these entry-level firefighters were trying to seek promotions to. The test would contain both a written and an oral examination. The test reflected a 10th grade reading level or below. What do we think of that? Anybody want to chime in? Should we require firefighters to have a 10th grade reading level? They had a time period where the firefighters, this test was announced that was coming up, and they could study for 3 months at their own time and expense. There were courses offered, but they weren't paid courses by the fire department. And then the test was actually conducted by experts in the firefighting field who had no relationship to Connecticut at all, because they were trying to remove bias. There were 77 candidates, and you can see for the lieutenant position how that played out. There were 41 candidates for the captain positions, and you can see how that played out. And if you do the statistical analysis on this, we do violate the 80% test with respect to Blacks and Hispanics. The city, accordingly, before they ever implemented this, the candidates knew the results, but the city threw out the test and said, we're not going to promote anyone based on this test because of disparate impact. All right, folks, tell me what you think. Was that the right decision? I know there's people on this call. What do you think? The city threw it out. Okay, we're getting some response that that's what you would do too. Anyone else? All right, so the Supreme Court, there was a lawsuit. The Hispanic firefighters who passed the test sued and said, hey, this is Title VII discrimination because the city threw out my results. I passed. I'm one of the few Hispanics who passed. I would have gotten that promotion, but they threw it out, and now I don't get my promotion. What did the Supreme Court say? The Supreme Court agreed with the Hispanic firefighters and said, hey, you bad employer there, you made a decision that your test would have disparate impact. And maybe you were right, maybe you were wrong, but you shouldn't have thrown it out because all these people studied for it, and at least some of the minorities passed, and you should have given them the jobs. If you are the employer, do you feel like you can't win right now? If you're the attorney, I can tell you, I would feel like I couldn't win because I have the other decision saying, hey, bad employer, you had problems with your test. And now we have an employer who proactively says, hey, I think we've got a disparate impact and we failed the 80% test and I'm throwing these out. We're going to start with a different system. And the Supreme Court says, no, that's not right either. you should have promoted the candidates who passed. This leaves a lot of difficulty for employers. So, what's the takeaway here? You can't win. That's the takeaway. No, the takeaway is when you have minorities who do pass what might otherwise be a disparate impact situation, you need to give careful consideration as to whether or not you're actually going to promote at least them anyway, and then deal with the remaining folks, because at least some of them have passed and spent considerable time in this case and money and energy studying for this exam. Okay, moving along. This came up all the time when I practiced, and it's probably the most common scenario that you will get under a disparate impact type of situation. Layoffs, right? We all have them. Stuff happens. We decide we're getting rid of Department A, or we decide that, you know what, we need to cut the workforce by 10%. Inflation has hit us. We need to do something to control costs. And so every department has to get rid of one person, or, 10% cut across the board, or we're getting rid of Department XYZ. What do we do? So in this case, which also made it to the Supreme Court, we have a layoff of 31 individuals. 30 of them are over the age of 40. We have the Age Discrimination and Employment Act, which covers employers with 20 or more employees. And there's lots of state and local laws that mimic this law that cover employers that have much smaller employee populations, usually down in Pennsylvania to about 4 employees. So this company said, hey, we want to do these layoffs fairly. We want to do them ethically. We want to do them correctly. So we're going to look at some factors. We're not just going to have managers, pull a name out of the hat or pick the employee that they like the least. We're going to look at 4 factors: performance, years of service, and performance was based on the performance reviews that they had done yearly, which was, when you're in this type of situation, is very helpful to have those. The employee's flexibility. How do we measure that? We can look at the number of shifts that they've covered or things like that. We can look at whether or not they can perform multiple functions within the workplace. Can I do function A, function B, and function C, as opposed to Susie, who's only trained to do function A? And the criticality of the skills. So maybe our biggest clients need skill A, and it doesn't really matter. Most of our business doesn't come from skill sets B and C. The trial court found in favor of the employees, as did the circuit court. What does the Supreme Court say? Gosh, I'm afraid I've put everybody to sleep here. I'm not getting any responses. So the Supreme Court said, hey, we agree. We don't really like this, even though you've got factors here, because 2 of the factors require a lot of discretion on the part of the supervisors. So years of service is pretty black and white. Performance, theoretically, if there's a history of performance reviews, it's pretty black and white. But flexibility and criticality of skills, it's open to a lot of subjective input from the managers who are making this decision. And the Supreme Court came up with a test and essentially said, if an employer wants to defend a layoff like this, the employer bears the burden of proof to show that reasonable factors other than age were the reason for it. And in this case, the Supreme Court didn't think that burden was necessarily met. So RFOA is the affirmative defense when you have a statistical lopsidedness thing like this, where 30 of our 31 folks are over the age of 40 and in a protected class based on age. One of the takeaways here, if you're looking at a layoff, and I know this isn't always possible for smaller employers, but certainly if you're larger, one of the beauties of consulting with a labor attorney, and I don't do this anymore, so I don't have any skin in this game. I'm not trying to drum up business or something. If you talk to employment counsel and say, this is what we're thinking of, this is our employee spreadsheets, this is what we're doing, that gets protected by the attorney-client privilege. And so that can be looked at and discussed with the attorney with that cloak over it, so that you may want to massage the numbers or massage the test or massage whatever, so that you feel confident, or as confident as you can be, that what you're coming up with is not statistically significant for any protected class: women, minorities, age, sexual orientation, whatever, that you don't have that, or if you do, you can defend it by saying, we have a business justification for this. A case that I had was a company that had multiple locations, and they chose to shut down a location. They were losing money. They shut down a location that was in a primarily Hispanic area, and most of the employees in that location were Hispanic. There was a lawsuit because those employees said, hey, you shut us down, but you had other locations that you could have shut down that were all predominantly non-Hispanic, and you chose us instead. And how do you justify that? Right? The justification that we argued, at least, was, hey, you were the poorest performing call center in terms of the number of calls per cycle, et cetera. But you need to look at those things too. If you shut down a store, did you just shut it down with a group of employees that are predominantly a certain race? Why did you shut down that store as opposed to the one that's got Ann Lavelle and all of her, white friends working in it? You have to be able to defend that, even though it might look on its face that, hey, shutting down that store was okay. The EEOC has jumped into this mix too. So the Equal Employment Opportunity Commission has said, hey, we recognize that this is a big issue, so we're going to give you employers a gift. Who doesn't want a gift from the EEOC? And so you can see the link there. Hopefully it works. And if the link doesn't work, you can just type it in. But they have a whole document that they have put out that addresses disparate impact and what they think about it. And they have some examples in there. And so one example is, hey, you've got a police department with patrol, foot officers, right? Positions. They're going to have to pass a physical fitness test. But we know, and the reason they have to do this is because they have to chase down suspects and handcuff them, I guess. It might exclude older workers because, you get somebody like Ann's age and she might not be able to run as fast as that 20-year-old. Guaranteed that's true. In this case, the EEOC says, hey, if you can tie it to a business necessity, we're okay with that test. We're okay with it without you even adapting it for Ann's age group, which is, the ones who are over the hill. And even if Ann doesn't get the job, well, that's tough luck for Ann because you've articulated a business necessity for this. Now, you often see organizations that say, hey, we're going to have a slightly different test for different genders because we recognize inherently most women can't do the number of push-ups or the number of this, that, or the next thing that men can do. So oftentimes that modification is made, and there's often age modifications too. But it's something to look at and say, do we need to make an age modification for a test or a gender modification? Because we know statistically Ann can't run as fast as the 20-year-old. Ann's not even going to try to run. So that's a different story. But we have to be able to tie it to business necessity. And the problem is this EEOC example, they're imagining facts that may not be true in real life because a lot of police officers are driving cars, right? They're not necessarily, the majority of the job may be driving a car, going in, taking reports, taking accident reports, not necessarily chasing down crooks on foot to handcuff them. And so you might look at this and say, well, what percentage of these folks actually are performing that duty, and how important is that duty to the overall job that we've got going here? Similarly, if we have a nursing home that decides to make job cuts, now oftentimes folks will be like, we need to cut some of our highest paid folks. They're often the oldest folks because they've been there the longest, right? So you have to be very, very careful of that. To ensure that supervisors are making good decisions with this layoff, the employer trains them to pick employees that, based on objective factors, such as the number of patients served, errors, outcomes, etc. Those are objective factors, in theory at least. And the EOC says, hey, that's fine, even if a bunch of older workers get selected, because we have trained our supervisors and we've articulated, theoretically at least, objective reasons as to who's getting picked and who's not. They contrast that though with the next example to say, hey, if you just tell your, and this happens, especially in smaller companies, hey, pick your least productive employee and we're doing a 10% layoff and they're going. That would not meet the scrutiny of the EEOC because you haven't guided or trained your supervisors on how to pick the least productive employee in your workplace. And therefore, there's a lot of subjective factors that could go into that might reflect bias against a particular protected class, whether that's age, sexual orientation, gender, race, ethnicity, religion, anything under the sun. And remember, discrimination can go both ways on almost all of these except age. We don't protect the young and stupid. We only protect the older, seasoned, wiser employees. But it can go both ways. So I've had a case where a company that was minority owned and had almost all Black employees fired a white person. That person turned around and sued and said, hey, I was selected for layoff because it's a minority owned company and they prefer other minorities in their workplace. And I was the only white person in the finance department, and that's why I got picked. It wasn't that I was the least productive or the least competent or whatever. So if you do a layoff and you're looking to have your supervisor's input into what's going on here, it's important that you give them some guidance, hopefully objective guidance, to say, these are the factors we're going to look at. This is what you're going to do. All right. I'm sure that's all crystal clear now. I appreciate everybody's patience on that topic. Hopefully that gives you some thoughts of how to root out what looks like facially neutral policies that might be a problem in your workplace that you might have going. Remember, we usually do these webinars based on ideas out of our clients and friends. So if you have anything, please let your CTR rep know. And also, we're doing the Compliance and Cocktails August 8th. I think it's 4 to 6 at Walnut Grill. And we'd love to see folks there as well. And we can have a more interactive discussion, hopefully. So with all that in mind, if anybody has a question, please let me know. Otherwise, have a wonderful summer. Hopefully the weather picks up here a little bit today. It looks better. Try to stay cool and enjoy. Thanks so much, everyone.